Very good evening to all the participants. Uh, as part of its weekly online lecture series, the DPIIT IPR Chair, Osmania University, is pleased to organize the 8th online lecture today with Professor H.A. Kadri as the resource person. And this is one topic uh, which, in fact, is the most significant in the minds of not only the law teachers, researchers, or practicing advocates, but also the inventors and innovators. Like, what exactly is the subject matter of patent protection? And we have one of the best legal brains as far as intellectual property rights in India are concerned, Professor H.A. Kadri, to speak on this topic. And without wasting any of your time, I would like to give a brief introduction about the resource person, Professor Kadri. Dr. Kadri is currently Professor of Law at Gokul Education Society's N.B. Thakur Law College, Nashik in Maharashtra. And he is also a member of Faculty of Humanities of Savitribai Phule Pune University, Pune, and also a member of the Association of Asian Constitutional Law Studies, Singapore. Kadri has 21 years of experience of teaching at the undergraduate and postgraduate level. He obtained his PhD on IPRs and precisely in patent law from Osmania University, Hyderabad. And his articles, which are published on IPR and other topics, are in some of the well-known internationally reputed journals. And in fact, some of his articles are also published in the journals listed in SCOPUS. And if you look at his citation index, it's really impressive. And Dr. Kadri is into serious research, having completed a minor research project of Savitribai Phule Pune University as the Principal Investigator. Then he is regularly participating in several national and international conferences in India and abroad, mainly in countries like Singapore, Thailand, Philippines, etc. And he himself has organized many national and state level conferences and also delivered as resource person more than 75 lectures in many reputed institutions and HRDCs, formerly called academic staff colleges of several universities in India. And he is also credited with, the experience of working as subject expert in more than 25 committees. At the personal level, I have a great, relationship with Professor Kadri because I knew him since his days as a PhD scholar, and we traveled together even to foreign countries like Singapore and Thailand. And we also published one very well received article in Journal of Intellectual Property Rights, which has a very impressive, in fact, citation index, which is on the local working requirement of patents. And we received appreciation from many, including late Professor Shamnath Bashir, a doyen in the field of IPR education. And all the participants may, in fact, enjoy his lecture, may rewind the clock back to 1980s, may, in fact, even refer to the judgment of US Supreme Court in Diamond versus Chakrabarti, the majority, the minority, like anything under the sun can be patented. So I'm talking about Pseudomonas aeruginosa, bacterium, which was genetically engineered by Dr. Anand Chakravarti of General Electric from India. So over to you, and I present to you Professor H.A. Kadri.
Yeah,
Kadri, sir, please.
yeah. Very good evening to all. Respected GB Reddy sir, who is my mentor. At the outset, I thank all the organizers, Dr. GB Reddy sir, and his staff for inviting me and for giving me an opportunity. Today's topic is patentability of inventions in India. Uh, Friends, as rightly said by Reddy sir, that we did some research together, and in fact, I studied for the first time this subject of patent during my PhD, and before that, I never studied. By that was not my subject, so I developed this only through research. Patent has acquired such an enormous importance in this present era because of its significance, economic significance, technological significance. Therefore, it becomes very essential to understand what are the patentability criteria, patentability of inventions, the criteria for patentability, the non-patentable inventions. Before that, we'll discuss what is patent. So patent is something which is a privilege granted by government for an inventor for his invention. I may recall the call of king in council during the 13th century when England was lagging behind the other lower countries, and the other countries were developing the glasswork and progressing in technology. The king in England realized the importance of technological advancement and gave a call uh, to call to the skilled workers to come to England and settle there, and assured them the protection, assured them the space, the place, other facilities, and also assured to purchase the product with only condition that they should come to England and settle there and give an opportunity to English people in the working. So, in this is a reward, a privilege granted by the state, and now it is in the form of law, which grants an inventor a monopoly privilege. It is reward for the creation of something new and useful, which might benefit the public. It confers an inventor an exclusive right to make use, exercise, and vend his invention. So, friends, if it is not protected, the invention which is with you may be used by the public, for which you may not be able to get a reward. So the patent system is in fact a reward system which ensures something in return for the work which you have, for the invention which you have developed, the labor which you poured, the skill you utilized, the experience you utilized, and the advancement you brought into the existence. Uh, Patents are granted only for these are some of the characteristics of patents that before to begin with patentability, just I am going through some general information for the understanding of the audience that what are the characteristics of the patent. Patents are granted only for 20 years from the date of application. So it is for the fixed duration of 20 years and not more than that, not like real estate or other properties which are permanently inherited, and it goes on to pass, goes on, and it is going, it is being passed on to the generations, from generations to generations. But intellectual property, more particularly patent, is not like that, and it will come to an end after 20 years. It is further subject to certain conditions of renewal, compulsory licensing, and local working requirements, and so on. Again, the patent right or ownership of patent does not go beyond the geographical boundaries of the country. These are some limitations and characteristics of patent. The point of why to grant patents. Friends, patent add fuel to the fire of genius, the intellectuals, because if you reward the intellectuals for their work, they will go further and develop more and more and more. So commercial monopoly stimulates further invention. If monopoly is granted and some commercial benefit is granted or given to the inventors, it will further stimulate the invention. That is the reason state grants monopolies. It encourages research and invention. More robust patent system will encourage more research, more invention, more R&D, research and development, more investment in R&D. So it is an incentive to invest money. It is an incentive to invent. It is an incentive to invest in research and development. Therefore, patent plays very important role in bringing new technology to the society, bringing or in the national welfare, in the economic welfare and scientific development of the state. Further, grant of patent excludes the chances of reputation, because through the process of registration of patents, we bring all inventions together on record, and the common people may go through those inventions which uh, excludes the chances of repeatation of the same research being done again and again. It also ensures economic growth, which is very expansive, explosive, unplanned. Therefore, patent system is a robust patent system is very, very important in economic growth of the country and even the whole globe. The patent system encourages inventors to disclose their invention. There are chances that the inventors may die without disclosing those inventions because of the fear that it will be used by the public and nothing will return to him. And that is the reason patent system ensures the inventors that their invention will be protected, and if somebody has infringed his rights, he will be able to file the suit for infringement and recover the damages caused to him. Therefore, it encourages disclosure of the inventions. The disclosure enables the general public to use the invention efficiently after the expiry of monopoly period. Once the patent term of 20 years expires, the invention will be available to the public, and public will be able to use it without payment of royalty. It is further useful to studies and research even during the period of patent protection. Then, what is patent? Patent rights are available. Herein, patent is a monopoly which is granted by the government to the inventor or his assignee. Herein, patents are granted to the inventor. Inventor is the person who has invented, or it may also be granted to the person who is an assignee if somebody has assigned his invention to somebody else. So, patent is a right to make use of that invention in his own industry by manufacturing, or he may transfer it to others by sale, by license, or by any other mode of transfer. It is only for the period of specific period of 20 years in India, and it is in consideration, or it is nothing but consideration for disclosure of the invention to the government, because we disclose the invention to the government and government provides you the protection. That is the patent office is the media, or the office where you submit your specification disclosing the invention, and in return you will get protection of 20 years. During that period, you will be able to enforce your rights through appropriate mechanism which is given under the law. Important aspect is that patent rights are available within the national jurisdiction, and patent is not available beyond the country, beyond the geographical boundaries of the country, and therefore patents are having only national jurisdiction. Now, patents are granted for inventions. Now, what do you mean by invention? Invention is either product or process. Product means any machine, device, apparatus, article, substance, process, or substance, etc. And process means it may be a method or manner of manufacturing any product. Herein, all products or all processes are not patentable. So, all products and processes which are created by human being may be inventions, but the protection is given only to specific inventions, or that means for the products or processes. If you go back to the law existing prior to 1995, uh, uh, particularly after 1970, when the Patent Act in India has been amended after the Rajagopal Iyengar committee report, the patents were given only to the process, and product patent was completely abolished. Further, the inventions in the field of drug, field of food, and pharmaceutical drugs and chemicals was given only for the process patent, that process only for a particular period of 5 years, keeping the in mind the importance of the drugs and food and the chemicals for the society. However, after the implementation of TRIPS agreement, India has been forced to amend its law, and now we have the product patent regime. So once product is patented, you cannot come up with a new process to get the patent. So what we are discussing today is very basic information, only for understanding what is patent, what is its importance, and what are the essential criteria for patentability. Herein, invention means invent a new product or process involving an inventive step and capable of industrial application. Herein, in an invention to be patentable should qualify three essential uh, requirements. The first one is it should be a new invention or a new product or process, and it should involve an inventive step, and it should be capable of industrial application. Now, the section 21J of Patent Act 1970 says that capable of industrial application means the invention is capable of being made or used in industry. So, generally, it is usefulness of invention is relevant here. If any invention is useful, if it can be made or used in industry, or even if it has some potential to be used in future, it is enough to fulfill this criteria. Uh, but it should be new. We will be discussing all these three ingredients separately in detail in subsequent slides. It should also fulfill the criteria of inventive step. In India, in the Indian patent law, inventive step has been defined as a feature of invention that involves technological advance as compared to the existing knowledge that makes the invention non-obvious to the person skilled in art. These three essentials we are going to discuss in detail for a complete understanding of patentability criteria. Let us discuss one by one, which is the most important aspect, or which are the most important aspects of patentability. Now, new invention. If you read the provision in detail, it provides that new invention means an invention or technology which has not been anticipated by publication in any document. So, an anticipation or prediction uh, about any future invention or disclosure of any invention in any document uh, in India or abroad, uh, in anywhere in the world before the date of filing of patent application. It includes publication of or anticipation of any invention uh, by publication in document. Herein, anticipation by use or anticipation by public knowledge has not been included in this definition as such. However, anticipation by publication in document, uh, it includes any specification, any article, publication by specification filed in patent office, any article published in any journal, on website, or any magazine, or any document anywhere in the world. It gives rise to an idea of absolute novelty requirement by the Indian patent law. Uh, Whereas in America, till 2011 America Invents Act, this concept was not there, which we have right from 2005 or even prior to that, that for grant of patent to any invention, it should be new, and for it being new, it should not be anticipated anywhere in the world through any publication in any document in any form, electronic or otherwise. Second condition for novelty is that the subject matter has not been fallen in public domain. Public domain means something which is not protected by patent or any intellectual property. So if it is part of public domain, it will not be, or it shall not be patented, or it does not form part of the state of art. Here in state of art means something or existing knowledge, existing technology on the date of application. So anything which is already existing cannot be patented again. You cannot go on preventing the existing users, existing inventors, existing holders of copyright or any other intellectual property, existing users of any invention from their use, because they are already using that. Therefore, anything which is published, anything which is anticipated by publication, anything which has not which is part of public domain, anything which is part of state of the art cannot be patented because it is not new. Herein, new means something which is not existing on the date of publication. But what is that which is something in existing, or how to determine what is existing on the date of publication? It is to be determined through search, and that search will be done by the patent office through online resources or offline resources, depends. Uh, as compared to the relative novelty, we have adopted absolute novelty, and as I already said that in America there was relative novelty till 2011, when it has amended its law through America Invents Act and brought absolute liability in parallel with Indian concept of absolute novelty. In case of relative novelty, it is relative to any jurisdiction, like for European patent law, it is the whole in the Europe only. If something is published in Europe, it is not new. But in case of India, we have Indian patent law, and anything which is not published in India, we may consider it as new. But we have absolute liability principle, and therefore anything published beyond the geographical boundaries of India shall also be considered as not new, because we have adopted the absolute liability principle. In America, the provision before 2011 uh, was that wherein they used to accept as a new anything which is not in use in America, or not in public knowledge of Americans. So anything which is not known to America was being patented in America, because what America does not know is not known to the whole world. That was their assumption. However, fortunately, it has been amended, and now even America has adopted the same principle which we have adopted even prior to US. Publication of an invention by public use, public information, public knowledge, either orally or written, is sufficient for rejecting the claim of grant of patent in India. So, publication through any means, in any form, maybe in written form or oral, in public use, which is not published anywhere as such, but it is being used somewhere, like traditional knowledge is in use. There are some communities in India who who use certain knowledge in their day-to-day life, and that becomes the prior art, or that becomes the a part of public domain, and that can't be considered as new, and it does not fulfill the criteria of novelty. What whatever is already available in the public domain cannot be patented, as one could not be prevented from using what is already in use before the grant of patent. That I already explained to you. Novelty excludes from patenting the entire existing knowledge prior to the filing of patent application in any form, anywhere in the world. Herein, our law provision relating to novelty is so robust that it excludes each and every existing knowledge or technological information existing prior to filing of patent application in any form anywhere in the world. Now, the next step is the next condition for patentability is inventive step. Uh, Inventive step means a feature of invention that involves technical advance as compared to the existing knowledge or economic significance or both and not obvious to the person skilled in the arts. See, step has created an addition or provided for an additional criteria for grant of patent in addition to non-obviousness. So that is technical advance as compared to the existing knowledge or economic significance, which is not mentioned in TRIPS also. So first of all, an invention to be patented should be new, and then it should involve an inventive step or it should be non-obvious. Both are treated equally. Either you may say inventive step or it may be a non-obvious invention be non-obvious. Both are one and the same. Uh, Under the Indian law, inventive step means a feature of invention that involves technical advance. So technical advancement is a basic requirement for an invention to be condition of inventive step. Either technical advancement or economic significance. So if you consider economic significance and compare this with usefulness or industrial application, both seems similar. So there is some error here in this definition that the law requires utility in the inventive step itself, like this economic significance. So unless and until there is economic significance or some utility, the patent is not, the invention is not patentable, which is part of the industrial application itself. However, it has been brought into inventive step. Technical advance has been brought into the inventive step requirement so as to achieve the technological advancement in the field, and that you can say that it is purposefully added to bring an advancement in the technology. However, the TRIPS agreement has not provided for it, and it is therefore called as TRIPS plus provision. Further, an invention should be not obvious to the person skilled in the art. Not obvious means something which is next slide. Something sorry, something which is not obvious means that the invention does not go beyond the normal progress of technology, but merely follows plainly or logically from the prior art. So if you bring something based on existing in a natural course of action or natural flow, which is logically derived from the existing prior art, is not inventive step, is not non-obvious to the person skilled in the art. Now, if you do something unexpected, beyond expectation, if you do something which is uh, uh, surprising, which gives a surprising result, which is solving the existing technological problem, which brings some new product or process which was not expected, not predicted, or which is not a plain result of logically arranging the existing knowledge, only then it fulfills the criteria of non-obviousness. If you just go through the existing knowledge and bring something based on that, which is a plain and logical conclusion of what has been already invented by others, it is not inventive step, or which is not non-obvious to the person skilled in the art. Therefore, you have to bring something unexpected, something you have to solve the existing problem, you have to bring something which is a surprise, which gives a surprising result, unexpected result, then only you can say that it involves inventive step. uh, Obvious extensions or modifications of prior inventions or devices are not patentable even if they are new and useful. There are various obvious extensions. Suppose you fit a radio into or you embed radio into a new device, radio into computer that is already existing. So something which is already existing, just arranging into a new device or just mixing two or more things and bringing into a new one will not result into inventive step. Therefore, you have to prove two conditions. One is novelty and another is non-obviousness. In fact, non-obviousness is inbuilt condition of novelty also. Therefore, all inventions all inventions are all non-obvious inventions are new, but all new inventions are non-obvious. How? Because something which you do not know is also new. Something which is new for you may not be new for me. It depends upon your knowledge. So uncovering something which is already existing may be new, but it is not inventive step. If you discover any new rock, a new species of animal, new species of plant, which is already existing somewhere, but nobody was knowing that, that does not amount to inventive step, but it is already existing, which we were not knowing, but it has been uncovered, and that's why it may fulfill the requirement of novelty, but it is not an advancement as such, but it is not an inventive step, it is not solving the existing problem, it is not merely based on the existing knowledge, but you are adding something into the technology, you are adding into the knowledge, and that gives rise to a new product or process which with additional feature of technological advancement, or it may give some economic significance. So the example of economic significance is that in case of pharmaceutical drugs, uh, the those who are involved in manufacturing and development of drugs may be knowing, those who are connected with pharmaceutical department or pharmaceutical discipline, that a product may go through 3 to 7 steps or stages in complete production. By research, if you are able to reduce the stages in its manufacturing, that will reduce its cost and that may lead to economic significance. So therefore, it can be considered as economic significance and may be patented as such. However, this has been criticized for the reason that merely having economic significance is not adding to the, and even if it is not adding to the existing knowledge or not bringing any technological advancement, still is being considered as an inventive step, and therefore you are not going to achieve anything, not achieve the advancement which is expected, and not going to solve the existing problem, and therefore it has been criticized. So there are two things or two aspects. One is this particular definition of technological advancement expects the researcher to bring some advancement. However, the optional requirement of economic significance also affects the technological advancement. By bringing merely an economic significance, one can patent that invention, and therefore the ultimate aim of technological advancement remains unachieved. The third essential criteria for patentability criteria for an invention is utility or industrial application. The invention should be capable of industrial application, means it should be either used in industry or it should be capable of using in future. Any potential use is also enough, and there is no a very hard and fast rule about utility. Any remote or potential use may be accepted as maybe economic profit, any profit or economic significance or agricultural use or any other use in future may also be sufficient for this criteria. So this is an example. Next is an example of a very minor invention, but it brings a great change to the technological change and brings a great utility in the society. This is a picture of a straw. The first picture shows the old straw, which is just a straight pipe. However, it has created it could not solve various problems of drinking. First of all, when you are using a straight straw, you have to bend ahead and then you can suck the water from the coconut or the lassi from the glass. However, still something remains at the bottom and you are not able to drink the whole coconut water or the whole lassi, whole amount of lassi existing in the glass. So that creates a problem. Some part of the liquid remains at the bottom, cannot be used, and it goes west. Further, whenever you are using this straight straw, you have to bend on front side, then only you can use it. By standing straight or sitting straight, you are not able to drink the content of from the coconut or from any glass or any other mug, whatever. So a minor change has been brought into the straw, which bends from the upper side, and even if you are sitting straight or standing straight, the straw reaches the bottom on all corners of the coconut, and it by using that straw you can drink the whole content without a single drop wastage, and further you need not to bend. That is the significance of the straw, and it brings a very remarkable change in the existing knowledge. And even although it seems a very minor development, but it has a great economic and technological significance. This is just to show you how a small invention makes a great change. Now, even if all the three essential criteria are fulfilled, there are many various restrictions or various conditions to be complied by, then only the invention is patentable. Rather, the provisions in Section 3 and Section 4 of Indian Patent Act cut short the scope of patentability by putting a list of non-patentable inventions. Therefore, if you are coming up with invention, first of all, it should fulfill the 3 points requirement, that is the non-test, novelty, utility, and non-obviousness. And even then, you have to see whether your invention is patentable in Section 3 and Section 4 of patentability. As I already mentioned that for patenting an invention, you as a potential user or inventor, should not disclose the invention at all. Maybe you should not disclose it to any other person except some privileged communication. You should not make it public, or should not be in hurry to publish it in newspaper, magazine, or in article, because you may likely to lose, or you may sure to lose your your novelty as an essential condition for patenting. If you are thinking of patenting something, you should avoid publication or public use of that particular product. You should not bring it into public unless and until you file at least the provisional specification or a complete specification. That care you have to take. And further, you have to prove the patent office that your invention fulfills the criteria of non-obviousness or inventive step that we have already discussed in previous slides. Now, you have to further see that whether your invention is patentable. The important aspects of patentability are through the conditions of patentability are given in Section 3 and 4, because these two sections provides for non-patentable inventions, which decides the scope of patentability for any invention. First of all, it should not be contrary to the provisions of laws of the country. So any invention which is contrary to the laws of the country cannot be patented. Any invention, particularly invention in case of any arms which you cannot manufacture or develop, that invention, or invention which refers to any weapon which is which is illegal to possess in India, or uh, or if you come up with any invention in case of poison for committing suicide, it is prohibited in law. Anything which is prohibited law in law cannot be patented as such. Or an invention which is frivolous, which is silly, or which has very less value, or which has no significance at all. Uh, if you want to see just some examples of silly patents which are frivolous in nature. However, the American Patent Office has granted patent for a method of exercising an animal having natural tendency to chase. See, this is method of exercising cat which has natural tendency to chase, and just moving the light beam from one side to another side on a wall, uh, which is being chased by the animal, particularly the cat. So cat jumps from this side to other side and again reverse back, and that results in exercising that cat. So the method of exercise of an pet animal having natural tendency to chase has been patented in America, which is really a silly patent, which has been patented, which is not patentable in India as frivolous patent. If you go to one more next slide, it is a device to collect the excreta of dog, the defices of dog, which in fact doesn't add to the technology, or it's not nothing new, just arrangement or rearrangement of one stick and one utensil together gives rise nothing as such, and it is although a new thing, but it is frivolous, it is silly, and it is non-patentable as such. However, it has been patented in America because, as rightly said by Dr. G.B. Reddy sir, which has been mentioned in Diamond versus Chakrabarti, that in America, anything under the sun which fulfills the three criteria may be patented in America. That is the decision of United States Supreme Court in Diamond versus Chakrabarti. So their patent system is very, very liberal, and they patent everything, like the method of exercising cat, or method of the device to collect the excreta of dog. These all are silly patents which are not patentable as such in India. Non-patentable invention is the purpose would be contrary to law and morality or injurious to public health. Any invention which is contrary to law, that we already seen, contrary to morality or injurious to public health. So suppose somebody has invented specs or lens which by which you can see through the clothes or beyond the clothes. So you if you are able to see the body of other or the privacy of other by just using specs, it is immoral. Or if somebody invented a mechanism or method of committing suicide, is against the morality, against the public health, against the public order. Or method of breaking the signal. These are methods which are against law, against morality, against, or which are against public order, and there may be some method of committing suicide is also against public health, or method of committing you can say terminating the womb, or you can say terminating the pregnancy after a particular time period of 3 months provided in the law. So such termination of pregnancy which is not allowed in law, any new method or new device or new technology to terminate the pregnancy provided or prohibited under the law, it amounts to a non-patentable invention. Discovery of the principles and formulation of abstract theories which are only for discovery, they are based on common knowledge, and any theory or any concept like communism, sexism, all these isms which are merely abstract theories or which have no practical implementation or practical benefit as such should not be patented. Inventions relating to atomic energy in section 4, which the state has privilege and state has kept all the benefits, considering the benefits and utility of atomic energy in manufacturing the arms, as well as its use in creation of other energies. It is the state monopoly, and therefore state wants to keep it within the control, within the purview of state powers, and therefore it has prohibited from patenting anything which is relating to atomic energy. Among the non-patentable inventions, the mere discovery of new property or new use for a new substance, or the mere use of known process. Herein, this section 3D prohibits patenting of mere discovery of new property of or new use for new known substance. Herein, this provision has been brought to prevent evergreening of patents by extending the time period of patent term of 20 years beyond 20 years by patenting the same product for new properties or new use, unless it unless it results into new product or employs at least one new reactant, or it has the substance has enhanced efficacy. Enhanced efficacy of a substance can be calculated through therapeutic efficacy here. Therefore, if a substance, a chemical substance or pharmaceutical substance is used as an antibiotic, and if for a human body of 60 to 70 kilogram, if 100 mg medicine is to be administered, if the same dose has been reduced to 50 milligram with same efficacy, that means you have enhanced the therapeutic efficacy of that product, and therefore unless it results into new product or unless it results into enhancement of therapeutic efficacy, you cannot patent it. So section 3D prevents patenting of the known properties of new properties of the known substance, or new use of the known substance. At the same time, it allows the protection of the new use or new property of the known substance if it provides for enhanced therapeutic efficacy. Therefore, this section has been appreciated as well as criticized for having permitted the patenting of inventions which are already existing with an enhanced therapeutic efficacy. Next non-patentable invention is the substance obtained by mere admixture resulting only in the aggregation of the properties. So mixing two and more things together, producing a new product. Though it results into a new product, but it is merely an admixture of two or more, like a cocktail, and or arranging. Therefore, cocktail is something new, but it does not involve inventive step also. So this, even if it is permitted, it is very difficult to patent something which is aggregation of two or more components or substances together. The next one, the mere arrangement or rearrangement or duplication of known devices. So we have seen that now it is in Indian language you can say jugaad. So many people play with the existing devices and bring one jugaad that is very famous in India. So jugaad may not be patentable as such because it is merely arrangement and rearrangement of existing things. So attaching one or using radio on in the tractor, or attaching some new device to which is already existing in another, suppose now we have radio in your mobile which was already existing. So anything which has been existing previously, but which has been arranged or rearranged with different devices together to form a new use, it cannot be patentable as such. Method of agriculture or horticulture which is of public importance and public utility, that's why it has been made as non-patentable in India. Any process for the medicinal, surgical or curative use, or therapeutic use, treatment of human beings and animals which have great public importance, and that's why it should be open to the public, and nobody should own those methods of treatment and different diagnostic methods, etc., or surgical methods, and that's why it is not patentable. Plants and animals are not patentable in India, but TRIPS provides that there should be some generic sui generis method, and we have separate law for protection of plants, that is protection of farmers, plants and farmers rights act 2001. That's why it is not patentable as such. Mathematical and business method, as we know that methods of doing business or methods of solving any mathematics or mathematical problem, these are open to the public. These have importance in public, and as such there is nothing technological advancement into it, and that is the reason it should be made available to the public without any protection. Regarding computer programs as such, herein computer program as such, the wording is computer program per se, and the meaning of the computer program per se means the pure form of computers which are essential to have interaction between different components of the computer, like the interrelationship between the mouse and the keyboard and the CPU and the monitor. So any program to develop an interaction between these computer components of computer are called as computer programs per se, and these are not patentable, but these are copyright protected, maybe protected under the copyright law in India. So these are not patentable as such. However, any software or any application to a device or along with any device as a part of device can be patented. And in India, the practice is that any software which is part of a device, or which device cannot function without the software, is patentable along with that device in combination of device and software. Therefore, in India, although we have provision of non-patentability of computer programs per se, the other programs what does not form the part of pure form of computer programs may be patented in India and are being patented in India. Pure form of computer programs like Windows are protected under the copyright law in India. A mere scheme or rule or method of performing mental act or method of playing game. These schemes, there are various schemes, lottery schemes, schemes of methods, schemes or offers given by Big Bazaar, offers, schemes given by any company. These are new. However, in case of life insurance policies, which are based on some software and hardware, are protected under the financial innovations, and there are examples wherein the patent office has permitted patenting of these schemes in the form of computer programs part along with its utility. The presentation of information in the form of PowerPoint presentation or any other presentation is part of copyright. Topography of integrated circuits is separately protected under the law, and that's why these are not protected as such as a patent. Now, traditional knowledge, which is an knowledge of knowledge which is developed generations, particularly the Adivasis and the rural areas, the local people develop certain knowledge which they pass on to the future generations through their practice for hundreds of years from generation to generation, and it is there in public use, although it is not published, and that is traditional knowledge which is developed by our forefathers, our ancestors, and passed on to the generations from generations, that has great importance to the society, as well as it is although it is technological development, but it has been developed by our ancestors and we have not developed it, and that is of public importance and already is used in the public, and that is the reason it is not patentable as such. These are some non-patentable inventions. In fact, 6 o'clock, that's why our time is off. With this, I conclude with the essential, with the important takeaway that for any invention to be patentable in India, first of all, it should be new, and means it should not be anticipated in anywhere by any publication, in any document anywhere in the world. It should not be in use. It should not be form part of public domain or a state of art existing knowledge, and it should not be it should not be published, or it should not be part of knowledge of the society, because it becomes old, it ceases to be new. Further, it should fulfill the inventiveness, or the condition of inventiveness or non-obviousness. Non-obviousness means something which should involve technological advance as compared to the existing knowledge, or economic significance, or both, and it should also be non-obvious to the person skilled in art. The person skilled in the art is a person in the field who has some common knowledge of the field, which has been said by the court in various cases, and therefore a person of having common knowledge of the field, if for him, if the invention is obvious result of the existing state of art, or obvious conclusion of the existing knowledge, drawn from the existing information and technology, then it is not non-obvious to him, and therefore it's not patentable. Third one is industrial application, that it should be of use or utility, and this third condition is not that much strict as compared to 1 and 2, and therefore any potential use, if proved, is sufficient to find it patentable.
Professor Harunrashid A. Kadri, sir, it was a great honor and privilege to be associated and with you for this lecture. Sir's lecture was scheduled for the last week, but due to some unavoidable circumstances, sir himself arranged it for the next week and readily agreed. Thank you so much, sir. And I also thank the participants for their active participation, and also the queries that they have posted, which makes the interaction lively. And thank you for your support and continuously participating in our lectures. It actually encourages the chair, and it fulfills our objective of disseminating the information on IPRs. We'll meet again next Saturday at same time at 5 p.m. Thank you so much. Bye.
Thank you all. Thank you, sir. And thanks, GB Reddy, sir,